So my name is Curry Sautner. I'm the Chief Learning Officer at the National Constitution Center. And I'm so excited today's class is all about the Bill of Rights. And we are so honored to have this amazing person speaking with us today, Linda Monk. So Linda Monk, I have known for at least, I'm thinking 15 years, Linda. We've known each other about that long.
Yeah, and I was there at the beginning before it was open. So Jeff and I, in fact, were in the same class of visiting scholars in 2003.
That's amazing. So Linda Monk, I and many of us know as the Constitution lady, but she is more than just that. She's an amazing person that teaches us all about the Constitution because she's a constitutional scholar, because she's a journalist, and also because she's an award-winning author. And when I first started at the Constitution Center, it was your book that my boss had given me and said, this is what you need to read. The words we live by start here. And I was like,
I appreciate that. And as you know, it was the initial iteration of the interactive Constitution. I'm proud of that too.
It was really awesome. So we're honored to have you here today. And we are going to be led in this awesome discussion by our top scholar at the Constitution Center, Jeff Rosen. So Jeff, would you like to say hello to everybody?
Hi, everyone. And hi, Linda. We're so excited to have you. We can't wait to talk about the Bill of Rights. But Curry, I know we've had a lot of questions about the election. This is election day. And I thought I would just very quickly start by screen sharing a great blog from the National Constitution Center written by our web editor, Scott Bomboy, that will answer, it will answer any constitutional questions or questions that people have about what could happen next in the courts. So here it is. And Constitution Daily is a great place to look for nonpartisan information. Curry, did it come up, the screen share?
It did. And I'm so glad you started with this because we really need like an updated brief on what's going to happen next.
Yeah. So let's just quickly see what Scott has to say. First, there could be questions or challenges contesting the results in particular states. How long can those challenges take place? Until December 8th, which is the date when the Electoral College meets in every state. So Scott tells us that different states have different laws about the grounds under which you can challenge a result. And he has a bunch of different scenarios. In Nevada, for example, you can have 6 grounds for contesting an election, including where illegal or improper votes were counted, legal or proper votes were not counted, or some combination of the two. So basically you can say it was wrong to count those votes or you missed some votes. In Wisconsin, there may be a request for a recount. In Georgia, there is certainly going to be a request for a recount because the margin is so small, less than 1,000 votes. Recounts, just for your historical information, tend not to change the results. The initial vote counts are generally pretty accurate. Bush v. Gore came down to about 387 votes. The recount was stopped by the Supreme Court, but even after the media organizations did a recount on their own, they found that the numbers would have been pretty similar under the counting rules that Vice President Gore had requested. And then we have this very important date, December 8th is the safe harbor provision. States have to settle their disputes and determine their electors 6 days before the Electoral College meets on December 14th. So if the states settle out any of their disputes by December 8th, then they can be assured of having their votes counted on December 14th when the Electoral College meets. December 14th is when the Electoral College meets. We go down a little bit here and we see that everyone gathers in the 50 states and DC and casts electoral votes. What happens if an elector doesn't vote for the candidate he or she is pledged to vote? Well, the US Supreme Court said last June in this Chiafalo case that states can punish or fine electors of up to $1,000 or more. Some states don't fine their electors, but in the past, faithless electors haven't shifted elections, so we're not going to expect that to make a big difference. And then Congress has a law saying, hey, states, you've got to submit your slates by December 23rd. And then Congress counts the electoral votes on January 6th. Could there be any curveballs? There's one case pending before the US Supreme Court that says that any ballots that arrived after Election Day should not be counted. There are some very interesting opinions by Justices Kavanaugh, Alito, and Gorsuch about whether or not late counting ballots should be counted, but I won't get into the details of those right now because we've got to start talking about the Bill of Rights. But the bottom line there is the US Supreme Court is very unlikely to intervene unless it looks like those votes could make a difference. And it appears right now that they won't, that if Vice President Biden maintains his lead in the state, or even if President Trump retakes his lead, it won't be because of the late delivered ballots, because there aren't very many of them. And the final thing to say is that even if those ballots did make a difference, some of those conservative justices who believe that state courts can't change deadlines imposed by legislatures might still say the ballots can be counted because voters relied on them when they cast them. And there was a South Carolina case where Justice Kavanaugh joined the Chief Justice in saying, even though he thought it was wrong for a federal court to order signature verification, nevertheless, voters who'd voted without that verification could have their votes counted because they relied on it. Okay, that was a really intense update. Good, because it's, so important to know what's going on in the courts, but you can check out more by reading this blog carefully and also by reading the Supreme Court opinions. Okay, Curry. Now, Linda, forgive me for waiting to jump right into our exciting discussion of the Bill of Rights. Curry, how do you want to set it up?
What I'd love, Jeff, is I know you have so many questions. Oh, sorry. What I'd love for you to do, Jeff, is to dive into those great, amazing stories that Linda has uncovered and shared with so many of our teachers and students, to make sure that all of our students online really dive into it. And it always starts with, what is the Bill of Rights and where do we have it? So I'll turn it over to you guys, and I'll be here working your Q&A in the chat and the Q&A box, okay?
Well, that sounds great. And let's take our questions for the chat, because friends, we want to give you the chance to ask Linda Monk questions. But Linda, let's start with Curry's first question. What is the Bill of Rights and why do we have it?
Well, our Bill of Rights, as you know, ratified in 1791, proposed in 1789, are considered the first 10 amendments to the Constitution. And I was thinking about how today's political debate reminds me of that debate about the Constitution and the Bill of Rights, because it was hotly contested. You had these two very passionate points of view about our national government. One said that, we don't need a stronger government. We've just gotten rid of King George and all of his minions. We like it the way it is under the Articles of Confederation, our first Constitution. And then you have another group of people, George Washington and James Madison among them, that says, wait a minute, we're not going to survive like 13 arguing brothers and sisters. We have to have a stronger central government. That led to the Constitutional Convention in May of 1787 in your city of Philadelphia. But in the process of ratifying that Constitution, it became clear that a Bill of Rights was going to be necessary for it to be approved. But it was a very contentious debate over the ratification of the Constitution. We think it kind of like the Constitution's a miracle that descended from on high. And we know from the debates that just was not true. And certainly from the ratification debates, it was Professor Akhil Ridamar of Yale says that the ratification of the Constitution was the most democratic event on earth at that time, because of the way it's set up, the broad people, not people as we would define them, but at least voters, of approving that Constitution. That had never happened before. And in those debates, those fierce debates, imagine in Virginia, one of the biggest states, if not the biggest state, James Madison, my hero, 5'4", 100 pounds soaking wet, going against Patrick Henry, flaming red hair, give me liberty or give me death, and he would do it. 6 feet, towering over Madison, and yet Madison is my little bulldog. He is gonna keep after supporting the Constitution, defending it in Virginia, and you'd think Virginia would be all for the Constitution anyway, because it was the Virginia plan and the Virginia delegation that proposed the main provisions of it. And yet you have people like George Mason, who had written the Virginia Declaration of Rights and said, we need a Bill of Rights. He said that at the convention. He was defeated. But at the Virginia ratifying convention and in other state ratifying conventions, it becomes clear that you're going to need those Bill of Rights to guarantee the Constitution's ratification. And when we get more into the history, which I hope we do in the first Congress, I'm going to show you again how Madison is just so persistent, is getting the job done, even when he doesn't get elected to the Senate, and you know he really wants to be in the Senate, but Patrick Henry is not going to let him be in the Senate because of all the points he's made in the ratifying convention. In those days, the state legislatures chose the Senate. You'll see how Madison is trying to get the first Congress to pay attention. We have to get this Bill of Rights. And yet Congress is really delaying. His own political allies, supposedly the Federalists, are making fun of him. Oh, there's Madison, the little saint of amendments. There's Madison. They referred to him as one of Jefferson's elves. And yet here he goes, because as he's trying to propose the Bill of Rights or get Congress to do it, Virginia and New York are threatening second conventions. You know, so we think we're in upset now with a greatly divided country. Imagine the Constitution is barely born. George Washington has barely been inaugurated in New York. And we've got this fight over, can we in fact get the Bill of Rights so that the Constitution will endure?
Wow, thank you for sharing that history, which is so exciting and so relevant. And I'd love to ask you more about James Madison, who's all of our heroes. We had the most wonderful conversation with James Madison last week. So Linda, he was so great.
Yes.
Tell us, why did Madison change his mind about a Bill of Rights? And then walk us through those ratification debates. As Professor Amar says, those constitutional conventions were so much more democratic than even the convention itself, because they were specially elected with very broad franchise. And then tell us also about the request by states like Massachusetts that they would ratify, but their compromise was that they would recommend that a Bill of Rights be adopted. They felt that conditional ratification that required a Bill of Rights would be void, but they made this recommendation. So walk us through that whole debate and Madison's role in it.
And then, of course, my state where I live in now, North Carolina, that refused to ratify until a Bill of Rights was added. And in fact, I gave Curry the link to it so it can go out to all the teachers. There's a wonderful letter that Madison wrote in August to Richard Peterson, I think that was his name, Curry, right? It's that wonderful letter. You know, it's toward the end. He's hoping the Bill of Rights is getting enacted. He's pretty sure it's going to. And he refers to the Bill of Rights as the nauseous project of amendments. So you can understand. I mean, he's a workhorse. He's worked all summer trying to get Congress to do its job and hold faith with the electors. And he gives 7 reasons there of why he's changed his mind. And the one that really strikes my heart the most is he says, because I am an honest man. When he was running for Congress in Virginia to be elected to the first Congress, he was running against, Mr. Student Council President James Monroe, the good-looking one, the tall one, and the anti-federalists really liked him better. But Madison swore in that election that if he were elected to Congress, he would become the supporter of amendments. And like he says, he writes to Thomas Jefferson. These letters are in my book. And Jefferson saying, you got to have the Bill of Rights. Every person on earth deserves a Bill of Rights. And Madison saying, Bill of Rights is a parchment barrier. And then ironically, it's Thomas Jefferson who writes back and says, oh, but you've got to have an independent judiciary and they're going to be the safeguards of the Bill of Rights. Now, of course, it's ironic because who does Thomas Jefferson wind up fighting but the Chief Justice of the Supreme Court? Well, back to the ratification debates. When each state would ratify, many of them submitted lists of proposed amendments. The issue, as you pointed out, was prospective amendment or subsequent amendment. And Massachusetts was one of the states that went ahead and ratified. They wanted the amendments, but they went ahead and ratified anyway, whereas North Carolina said, nope, we're not ratifying, nope. And Madison includes that in one of his list of reasons, is that he wants to bring North Carolina in the Union. So when I talk to North Carolinians, I'm always talking about how North Carolina saved the Constitution. They made sure that there was a Bill of Rights. Yeah, okay, so what, did I address all your questions there, or is there another piece I need to bring up?
I think that's wonderful. It's very helpful, as you said, to explain that some states recommended amendments and others said we won't ratify unless you propose the amendments, and that helped shape the debate. All right. What, there's a question from Colin, which is so good.
Colin's a fan favorite.
I know. It's really such an important question. He's put his finger on things.
I've been following him.
He said, the Ninth Amendment is super broad. How should it be interpreted so it's not just people have the right to do whatever they want, but also that people do have more rights than have just been outlined in the first 8 amendments? And friends, just to remind ourselves, the Ninth Amendment says, let's see if I can do this one from memory, the enumeration of certain rights shall not be construed to deny or disparage others retained by the people. So Linda, Colin, first of all, that's one of the biggest questions in all of constitutional law. So you're right that it's a broad one. Do you want to take a good stab at it, Linda?
Sure. The Ninth Amendment, and I go back really far to 1991 when I was working on the first draft of my Bill of Rights book and became a big fan of Randy Barnett, because at that time he was one of the few scholars actually talking about the Ninth Amendment. When I was in law school, one of my mentors, John Hart Ely, said, oh, believing in the Ninth Amendment's like believing in ghosts. Mm-hmm. You know, it's just natural rights theory and nobody really believes it that much. He was a utilitarian, wonderful guy, utilitarian. Then you had when Professor Robert Bork was being nominated to the Supreme Court, and he says the Ninth Amendment's like an ink blot, and we really don't want to look under the ink blot. Now you've got a whole school of libertarian scholars, Professor Randy Barnett being at the lead of them, that says, wait a minute, every word in the Constitution means something. And if every word in the Constitution means something, then judges have a responsibility. It's not just give the kitchen sink to the people and don't worry about it anymore. That yes, this is a source of rights, and our judges should be allowed to recognize those rights. Now they have rules about how you're supposed to do it, but to me, the Ninth and the 10th Amendment are paired. You have the Ninth Amendment that has rights retained by the people. How do we normally protect those in a constitutional democracy? Judges usually are a big part of the way we do that. Then you've got the 10th Amendment that's powers to the states. And the court kind of goes back and forth on that. It says, well, sometimes the court should be involved in that, and sometimes no, leave it up to the legislatures. So, Colin, I have a feeling when you get the definitive answer to that question, you'll be well on your way to a stellar legal career.
Well, you're absolutely right that there's no definitive answer, and that was a great introduction to the possible answers. The only thing I would add, and actually in 1991, I was also reading Randy Barnett and Professor Akhil Amar because I was writing a law school note about natural rights and the Ninth Amendment and whether we could have an unconstitutional constitutional amendment. And Colin, I'll spare you the details, but the thought was, if free speech is an unalienable right, then how could you have a flag burning amendment that presumed to alienate it? Anyway,
that issue's been raised before. It was raised with the 19th Amendment and the 15th Amendment. At least back then, the Supreme Court said, no, it's pretty much, if it's ratified, it's constitutional.
Absolutely, and you're absolutely right in the prohibition amendments as well. Colin, the one thing in Linda's answer was, of course, the $60,000 question is, what are the methodologies that judges will use to determine which rights are not written down but are still protected? Randy Barnett's theory is called constitutional construction.
Good luck unpacking that.
I find it, I'll have to confess to you, it doesn't provide extraordinarily clear answers about how you're supposed to identify those rights. It sort of extrapolates from the liberties that are protected and recognizes rights like freedom of contract that are not explicitly enumerated. In my little note, and again, this is just one of many, many efforts to try to figure out the answer to your question, I said, One way to figure out which rights the people consider natural or unalienable are to look at the state constitutions. Count them up. The original state constitutions identified a series of rights as natural and unalienable, including the rights of conscience, the right to alter and abolish government, the right not to be deprived of liberty without due process, and so forth. Some states have added new natural rights to their state constitution. California now calls privacy a natural right. So that would be one way of doing it. Just see which rights people in the states think are natural and unenumerated, and do it that way. But
well, and Jeff has been such a tremendous scholar about the right to privacy. If anybody has mapped out that territory, it's him. If I'm the Constitution lady, he's the Constitution guy.
Not at all, not at all. Anyway, Colin, thank you for flagging this crucial question. And the long or short answer to your question is that's the whole drama of constitutional law, is picking a methodology that you find persuasive in identifying which unenumerated rights actually are protected. And there's so many possibilities.
And one quick little footnote, and I am looking at the time. I mean, that's part of what I think was Justice Goldberg's big contribution, is saying we've done all this unpacking of what we're calling substantive due process, but it really fits more under the Ninth Amendment. That's textually, that's where it fits.
Absolutely. We have a great question from David Collins. Can you address, Linda, that the First Amendment wasn't really the first, it was the third, but the first two weren't passed?
The Jeopardy question of the day, exactly.
Absolutely.
And so when people talk about, oh yeah, it's first because it was the First Amendment, it's like, no, it wasn't the First Amendment, it would have been the third, but of all the substantive rights that are listed, those are the ones that are given pride of place. I say pride of place because that's the way the Senate put them together. Remember, Madison was going to kind of cut and paste. It was mainly going to be in Article 1 because that's where the powers of Congress were. So they wouldn't have been 1, 2, 3, 4 amendments like that. It would have been inserted. And then they put them at the end. And then the first two amendments, as you know, the one about reapportionment still hasn't been ratified because under that, I think Congress would be about the 7,000 people now. Exactly. And the second one, now called the Madison Amendment, became the 27th Amendment, project of a college student who set out to prove that, yes, indeed, a non-contemporaneous ratification could still count. And for those of us who are supporting the ERA, which we believe has already been ratified as the 28th Amendment, that example provides some evidence.
Wonderful. Well, you mentioned the unratified amendments, and I want to go back to the interactive constitution, and this is the origins and travel phase. You can find it in the drafting table if you click on any of the rights. So, Linda, there are a few more amendments that Madison proposed that weren't ratified, including his favorite in the bunch. Proposal 14th. No state shall violate the rights of conscience, freedom of press, trial by jury. Tell us about that. And why was it necessary?
You know, as we know, pretty early on, Chief Justice John Marshall helped establish in Barron versus Baltimore that when it says Congress shall make no law, that meant Congress, the federal government, and did not apply to the states. And then through a very complicated process, the court eventually agrees with them. Representative Bingham in the post-Civil War Congress proposed the 14th Amendment with a clear provision that said the privileges and immunities should apply to all, and he clearly meant that meant the Bill of Rights. Now, as we know, the court comes around and about and whatever, but now it's virtually established that all of the Bill of Rights, almost, not quite, but almost. And as you pointed out early in the week, even as recently as last term, another provision of the Bill of Rights was added.
Absolutely. We have another great question, speaking of the right to conscience, from Lois Coate. The New Hampshire Constitution has a right of conscience. If the U.S. Constitution Bill of Rights had the same, would questions like the right to abortion still be at issue? And I'm going to call up the New Hampshire language as you're answering that very important question.
Well, and you spoke early in the week, I think, and showed that the actual language of right to conscience persists pretty late in the legislative debates over the First Amendment. Right to conscience in terms of abortion. That's interesting, because there are many people who say that essentially where we are today, when there's so many mechanisms to move viability earlier and earlier in a pregnancy, is that it really does come down to a religious belief around when life begins. And that if you believe that life begins at conception, there's nothing that's ever going to be acceptable than protecting life at conception. If you don't believe that, and there are lots of illustrations of differing religious standards on that, then in that argument, you're being denied your own right to conscience. And certainly in terms of a woman and her own body and what can be done with her own body, is there any other provision in law where, because of someone's religious beliefs or rights to conscience differing, somebody has a right to conscience that stops with my body? That's the argument against it.
Thank you so much for that. And I'll just note that Professor Lawrence Tribe once claimed that he thought that restrictions on abortion should fall because they were motivated by religious belief. But then he changed his mind because he thought so many laws have religious or spiritual underpinning, including the prohibition against murder, for example, which is also forbidden by many faith traditions. So he thought that argument would sweep too broadly. And both he and Justice Stevens backed away from that argument for that.
Yeah, Justice Stevens back away from that, because he's always been the one that I've cited to fully develop that argument. I didn't know he had backed away from that. It was after he'd left the court, though, I would presume.
Forgive me, Professor Tribe backed away from it. I'm not sure.
Yes, I'm not sure Professor, excuse me, Justice Stevens did.
I think you're absolutely right. Michelle Williams says, in your opinion, is there a topic or issue today that you see will be proposed and may actually gain real national traction as the newest amendment in our time?
Well, again, if we set aside the fact that I, along with many others, believe that the ERA has in fact been ratified, so let's set aside that. What I'm hoping for is that we get a national voting rights amendment that clearly states that all American citizens have the right to vote, that sets up national standards for federal elections. And many of the provisions that we've seen in the Voting Rights Act that was enacted against former states of the Confederacy that had strong records of discrimination, I think some of those provisions should protect all Americans, that we should all be skeptical of last minute changes to voting procedures. And so that's I would like, there was a time when President Lincoln referred to all men are created equal as a way of incorporating a value that he felt like had not been fully expressed in the Constitution. He turned the Declaration and says, now let's make that part of the Constitution. I think the same thing needs to be done with consent of the governed. We've played around a very, very long time about consent of the governed and how that's really going to operate in our constitutional system. And I think we need to take that one by the horns head on.
Thank you for those thoughts. Of course, in practice, the possibility of such an amendment being proposed by Congress are low. But Linda, I will ask you this. Would you need a constitutional amendment, or could Congress pass such a voting rights law under its Article 1, Section 4 power? There
you go. There's plenty of evidence that Congress does have, certainly in terms of setting times, place, and manners of elections and things like that, perhaps even farther. At this point, I want a constitutional right to vote too, because the court has gotten more involved in questions of voting rights, et cetera. I want to make it clear, you've got the three justices from Bush v. Gore that said basically a state legislature can change the electoral votes at any time it wants to, because that's what the Constitution says. And I'd like to take that out of debate, that we, the people, in fact, have a constitutional right to vote for all of it. I mean, even for the House, which is the one that comes up most often, it's according to what the state legislature says. And I know we're time constricted, so I'll move on.
Thank you for all that. I'll just finally add that the likeliest amendment to be adopted would be a balanced budget amendment. That is the one that has more state ratifications than any other, aside from the ERA. S. Latimer asked, what is the ERA? That's the Equal Rights Amendment. And we'll set that one aside because its status is contested at the moment. But just a bit short of 2/3 of the states have proposed a version of a balanced budget amendment. And if one were to actually be proposed by Congress, that seems the one that is most likely to pass. Curry, what questions do you have as we begin to think about wrapping up?
I love that the balanced budget amendment. The students are like, oh yeah, balanced budget. It's really important. That's why we have more consensus around it, but that's the most likely one to happen. The last question I have for both of you is I'd love to be able to have the students walk away and walk into their homes, into their classrooms as part of citizens of this country and say, the Bill of Rights is really this for us as our country. So if we think of that theme and kind of the idea that Madison had around the Bill of Rights, Linda, what would you tell students about the Bill of Rights to know that this is this for you in our country?
Well, Madison said repeatedly about the Bill of Rights, but also broader, that the reason we write these rights down is not just because the Supreme Court has magical power or Congress or the president, is so that citizens will incorporate those ideals in their day-to-day life, and that they will day to day be regarded as the great defenders and upholders of these liberties. So in addition to it being a legal document with remedies under courts, it's really a civic education document that says these are the values to which we commit ourselves, and these values we will strive to uphold.
I love that. I love that this is your power. This is your values. Go forth and share. I love that idea. Jeff, do you want to kind of bring us home? I know you're going to want to share the Interactive Constitution again, because you can find all these. If you're not sure what the 7th Amendment is or the 5th, you can find them all in the Interactive Constitution. But Jeff, you want to give our students any parting words about the Bill of Rights? And maybe, I know you're going to do it, homework assignment?
Well, it's just so exciting, isn't it, to take to heart Linda Monk's reminder that the Bill of Rights is certainly a restraint on government. That's primarily what it was. It was a restraint on Congress. But the reason that it restrains government is because our entire system is premised on the idea that all of us have certain inherent rights that come from God or nature, not from government. We're born with these rights because we are human beings in a state of nature, and they include life, liberty, the pursuit of happiness. What was the pursuit of happiness? It was not just a right to do whatever felt good, but a responsibility to master our unreasonable passions so that we could be governed by reason rather than passion. And that's why Linda Monk's reminder to us that all of us have a responsibility as citizens during this important election season, not just to be guided by our unruly passions, our anger, our partisan factional dislikes and likes, but our cool reason to take second thoughts and to slow down deliberation so we can really be worthy of the founders' hope for a society in which we can pursue and obtain happiness. The whole point of the system is for us to be happy, and the founders thought we could only be happy through self-control, both on a personal level and at the constitutional level. And that's why it's so exciting to study the Constitution and to discipline ourselves. And your homework is just pick a amendment, any one of the Bill of Rights, the first 10, and dig into it. And make sure you look at those early drafts on the drafting table, watch the language evolve, and see if the evolution of the language changes your understanding of what you think that the right actually means. And if it did change your understanding, then write to me and Curry and tell us how.
And our students reminded me that this isn't homework, this is Jeff work. So Linda, if you want to add to their Jeff work, go right ahead. Jeff
work is just for fun. It's just out of sheer interest. You're not going to get graded on it, but I know you'll find it as exciting as I do. So I hope that if you have some free time this weekend, then give it a try.
Well, and am I on the screen? Oh, okay. And I would like to add that Jeff uses the word reason a lot, and I understand why, but I prefer the word conscience, because to me, conscience also involves empathy. And that was one of the things I think Madison was really good at, particularly when it came to separation of church and state. And so always consider empathy when you're using your reason too.
Well, that was why Madison thought that allowing us to use our reason to exercise self-control, exactly as you say, Linda, would allow us to put ourselves in the other person's shoes and also to serve others, because that is the whole point of self-control, so that we can master our unreasonable ego-based passions and serve others and the public good. That was the whole point of the system, and it is such a meaningful thing to be able to do.
Indeed.
Absolutely. Linda, thank you so much. It's so wonderful to learn from you and your enthusiasm, and your books are so great. That's other Jeff work, if you'd like it, friends, is to check out Linda's amazing books on the Bill of Rights and the Constitution. They're so inspiring. Curry, what do you want to send us out for the weekend? Your last word to you.
Well, I am going to send everybody an email tonight with a whole bunch of Jeff work. Linda's book will be on there, the great resource she shared with about Madison earlier. So I'll put it all together. So you'll have lots of fun work over the weekend. So it's so great to have you. We might make t-shirts that say Jeff work is fun work. We've already been discussing that in the chat. I think it's really funny. I love any hashtag we can get, but I have had so much fun today. And I thank you both so much for, building and wrapping this week all around the Bill of Rights and understanding kind of these individual rights of empathy, of conscience, of reason, to really help our students kind of move forward. And it's really fun wonking out with you two constitutional people, we'll say. So thank you both so much. Have a great week.
Have a great week. Good weekend. Thank you, Linda. Thanks, everyone. Bye.